8th April. 8th April.
Your Lordship, serial number 35, Your Lordship.
Serial number
35.
35.
35. Yes. Your Lordship, here I am appearing for the accused. Here the matter has been posted for orders on non-filing. Kindly a short accommodation may be given to file our objection.
9th April. 9th April. 9th April. Yes.
Lord, writ appeal in a service matter. So the learned single judge has dismissed it on the grounds that it is a termination simply settled, whereas it's not. We are contending.
No urgency. 28th of April.
PL matter, my lord.
29th of April.
From PL matter, my lord. Last day itself, my lord, this Alan court direct the government to submit a report in respect of the encroachment of forest land by the private respondent, my lord. So far, they have not filed any report, my lord.
Very good. Then you will come and we'll see.
It's not given, my lord.
Date is not given.
Date is not.
It will go after 12th of June.
Please.
If date not given only, otherwise no.
Till 17, lord. Which sort accommodation was
17. Is. What is it about? 17. Actually.
17.
Why?
Short accommodation. Short accommodation.
16th June.
Serial number 38, my lords.
For a short adjournment, Your Lordship.
My lords.
We need the services of the senior counsel. Unfortunately, today is some difficulty. Might be adjourned by me.
That is a non-compliance of office of
Bias.
office objection 53 shall be complied with within 3 weeks. Failing with, the appeal shall stand dismissed automatically without reference to or order of it.
My lord, seal number 23.
Remove
my
the
lords.
office objection. And
Let's,
if office objection removed, once the office objection is removed, the appeal shall be listed within 3 days thereafter.
Serial number 25, my lord.
Yes, Mr.
My lord,
Lords, pending matter, my lords. This matter was directed to be listed, lords, for consideration. There is an interim order granted. Lords, now there is a docket exposition on the basis of the matter pending here. There are almost 18 petitions which are filed before the learned single judge on the premise that this writ appeal is pending. Lords, the matter did not reach on the previous 2 occasions. Now the matter is listed on 1-4. Can I request, my lords, let it be on 1-4, but can it be taken up at 2:30 at 1-4, my lords? It's only for that reason I am. But from the last date, my lords, from 11/3 till today, there are 18 petitions filed.
What is the subject matter?
Lords, the subject matter, my lords, is that an order passed by the Revenue Authority to clear, my lords, the user of the property otherwise than for agricultural purposes. Since it's an agricultural land, my lords, is challenged before the learned single judge. Learned single judge has dismissed the writ petition, saying that the petitioners does not have locus and they will have to establish their rights before the civil court. That is under challenge before this honorable court. Lords, I am not for the appellant, I am for the respondent. Lords, on the premise, my lords, that this is a matter pending qua the property involved in this writ appeal. Now, my lords, there is a docket exposition before the learned single judge. Multiple petitions are getting filed, my lords.
Take up on first.
First at 2:30, my lords, if I can.
For that, no memo is made. You mentioned on that.
Very well, my lords. I am so
my lord,
grateful.
commercial application 1 of 25. This is a matter wherein we had specifically filed a memo stating that the subject matter of the suit is of commercial in nature. Therefore, it has to be transferred to the commercial court. But there was an order rejecting that prayer. The matter is of 2012 and the stage for evidence is already been recorded for the defendants. Therefore, the grave urgency, because the jurisdiction is a question in the matter,
Okay.
my lord.
It is pending.
Fresh matter, my lord. We have filed the commercial application before this court. Under section 15 of Commercial Courts Act, this honorable court has a power to transfer the matter from the city civil to commercial court.
It will not come here. Will it come here?
Commercial application 1 of them. Not an appeal, my lord. It's an application, commercial application.
In a pending matter,
No, my lord. It's a fresh matter.
you will verify where it is posted.
There's a grave urge.
No,
Commercial
don't.
application.
We are accepting memo only for the purpose of verification. Mention on Monday.
Please.
After the
My lord, seal number 23, my lords.
My lord, serial number 23, I'm appearing for the appellant, my lords. I pray for 23, my lords, 2-3. Senior has got some inconvenience today, my lords. I pray for 2 weeks accommodation, my lords.
8th of April. 8th April.
Serial number 25.
Commercial appeal, fresh matter, my lord. Execution proceedings are filed by the respondent, which is execution proceeding date is the 4th of April. I pray for a date before that, man.
4th of April.
Serial number 7, my lord. My senior is in the
My lords,
Serial number 7. So why you are taking time?
What?
Taking time?
Yes, my lords.
Why?
For a week, my lords. My senior's mother is admitted in the hospital, so he's
There you appear. You appear. You appear when it is called out.
my lords, 23, I
Serial number 34, my lord. I appear for the complainant, my lord. I'm seeking for a short accommodation.
20th April. 21st April.
Obliged, my lord.
Lordship, serial number 80.1.
80? 84.1.
I'm appearing on
There is no 80. There is no 80. 18.
what date?
Yes, what do you want? That the PIL electricity supply.
Senior counsel. Next week.
Oh, no, it will go to, if not in hurry, then it will go to 23rd April.
my lord,
serial number 25.
25. Yes. No, why? Very standard ground. Standard ground for all. Senior is not available. Difficulty, traveling. No, it will go to, it will adjourn sine die. If you mention the ground of senior now, it will be adjourn sine die and then you file it. We are not functioning at your convenience. At the request of learned the appellant, stand over to 26th of June as requested.
My lord, serial number 30, my
Then
lord.
suffer the, yes,
Serial number 30, my lord. I
Yes.
appear for respondent number 6.
35.
A week's accommodation may be given, my lord.
35. 26th of June.
my lords,
Not possible.
23, I pray
You
for
go
4
on
weeks
asking time and
accommodation.
we go on asking long dates. Every matter you are asking time, we are coming, reading and you don't conduct the matter. Yes.
My lord, 23, 8th is, I have inconvenience. I pray for 4 weeks accommodation, lords. 23.
No. 15th of April. Yes,
Serial
ma'am.
number 30, my lord. Serial number 30
30.
for petitioner, my lord. The respondent advocate intimate us to take an adjournment in this matter, my lord.
No. Monday. 30th on Monday if you are seeking to. 10 or to 24th as requested by
Respondents have filed their own
which one?
serial number 41, my lords. Respondents have filed their own writ appeal against the same order passed by the single judge. That's, my lord, fixed on 15th of April. The lordship should have it on the same date.
41.
41, please.
So 15th of April.
May I make a mention, my lords?
Serial number 21.
21. Yes.
Convenience. His husband had a cardiac arrest. Kindly have
It was stated that the learned civil counsel who is to conduct the appeal is in indisposed health. In that view, time was asked for. Full stop as requested. Stand over to 27th June. Yes, Mr.
Serial
May
number
mention
38, my
OVC.
lords.
38.
My lords, I have some health discomfort. I was supposed to appear and I was not able to. Pray for a week's accommodation, my lords.
28, 29th of April.
This month, my lords. It's a small matter. I'll finish in 5 minutes, my lords.
Maybe. Yes.
Any other mentions? Permission. Contempt matter. Serial number 1. Mr. Nandish Goda GB.
Complaint in this case, my lord. Complaint in this case, my lord. Complainant filed the petition papers on a court for writ of contempt, your honor. The honorable court has allowed on as per Annex A on 24/7/2024 direct the respondent to furnish the documents, my lordship.
No time limit.
Thereafter,
What did you do after this order?
your honor,
What did you do after this order?
I'm not clear.
Not clear, then
My lord,
be clear and come. What did you do after this order?
thereafter,
is nothing to be unclear.
where the application, Your Honor.
Where is that?
See Annexure B, Your Honor.
Where is that?
Annexure B in page
Annexure?
number 18, my
Annexure
lordship,
B,
page number 18.
page number 18. What did you say there?
Of made the application to furnish the
Compliance of
document
the
as
order
per
passed by the honorable court within 15 days. Notice returnable on 1st of, it will go to after now, 9th of June. Second is same? No.
So number 2,
My lord,
Stu-
in this act of
Srimati Bharti?
petitioner, my lord,
What did you do after the order passed?
I immediately gave a order copy to the Tahsildar.
Lev-
All letters have been mentioned.
Let us see your application.
My lord, in this, I have just few explanation for the reason for the
No, no.
delay.
Did you ask the Tehsildar to comply with the order
Yes, my lord.
within stipulated time?
Yes, my lord.
Where is that?
My lord, annexure B may be looked, my lord.
Annexure B,
B, page number 16, my lord.
page number 16.
I, not only one letter, my lord, I have frequently given intimation to them stating that there is a order passed by this honorable High Court.
There is no time limit in the original order, so you have to set down the time limit. And what is the direction?
The direction was to take immediately action against immediately imply the order of the Tahsildar, my lord. Tahsildar orders was not implied.
Right, an order dated 22nd August 23 and the directions contained therein passed by learner signature does not contain any time limit for the compliance. Full stop. It was submitted by learned advocate so and so for the complainant that subsequent to the passing of the said order, for my representation from application dated 11/8/23 was submitted to the authority, that's the Tehsildar. Full stop. However, in the said application also, the petitioner instructed the authority to comply with the order without setting down any time limit for compliance. Full stop. When neither learner single judge nor in the subsequent communication, the petitioner has set down any time limit for compliance, it is not possible to conclude at this stage that contempt of court is committed. However, since the order of the court should not go uncomplied with, the present contempt petition is disposed of by directing the respondent competent authority to act upon the directions issued by learned single judge and act in accordance with law in due compliance thereof within 8 weeks from within 8 weeks, full stop. The contempt petition is disposed of as not entertained, subject to above the rules.
So number 3, BC Venkatesh.
Notice returnable on 13th of June.
So number 4, Abhinay YT.
17th June.
5,
10th June.
so number 6, yes,
11th,
so Lohit,
11th June.
so number 7, to Devarajan.
12th June. Notice.
So number 8,
9th June.
so number 9,
Complainant.
to Pradeep.
Yes.
No, the interim order was issued by this honorable court.
Hmm.
No, restraining the accused
Hmm.
from putting up the mobile installation. Now kindly see page 31.
Hmm.
31 is the interim order. 33, my lord, 33 is the relevant portion. There shall be an interim order as against the private respondents proceeding with the construction for installation of the telecom tower in the 4th and 5th respondent property until the next date of hearing. I have submitted this order, my lord, to the accused.
It is interim order. Since it is an interim order, which factum could not be disputed by learned advocate for the complainant, Mr. So and so. The court is not inclined to exercise the jurisdiction of the contempt of court Act 1979 for the simple reason that at this stage no rights of the parties could be said to have been finally crystallized. Paragraph. The subject matter is at large. Subject matter including the interim order is at large before a single judge in the proceedings of the writ petition to be considered on their own merits, therefore leaving the petitioner to work out his rights and remedies, including the plea for breach of injunction, the before the learned single judge where the petition is pending. This contempt petition is not entertained and stand dismissed accordingly without going into the merits.
So, number 10.
Notice returnable on 13th June.
So, number 11.
Recreation club, my lord. There is a clear direction, my lord, not to interfere in the smooth activities of the recreational club, my lord.
Where is that?
My lord, they have willfully disobeyed. Sorry, my
Lords, I appear, my lords, for the complainant. By mistake, I think he may have mentioned, my lords. I appear for the complainant.
Serial number?
11, my lords.
11, yes.
Yes, my lords. Order is at, my lord, saying page 21.
This is the participation in the counseling.
Yes, my lords. 25th was the day of counseling, my lords, stray vacancy round. Direction was issued to permit the student to participate in the counseling.
Counseling was to take
On
place
25th itself, my lords.
25th
itself, my lords. In the presence of the council as well as on instructions, my lords, the direction was issued in the afternoon. By afternoon itself, my lords, interim order was granted, my lords. We have taken it, produced it to the authorities, asking them to permit the student.
Missed the bus, what can we do?
Apologies.
You have missed the bus because of their non-compliance.
Yes, my lords, but the fact that they have violated the directions has resulted in me, my lords, being thrown out.
Not permitted.
No, I'm completely thrown out. I am absolute merited student, my lords, government quota, backward community student who cannot afford, my lords, any other seat.
Willis, you noticed, I don't think any effective relief can be granted in contempt petition. Notice returnable on 3rd of April.
Great.
System number 12. To Vinod Kumar.
the complainant, my lord. There is a clear order that not to interfere in the recreation club activities, my lord. The two orders are there, my lord. Yet, my lord, they have.
So which order you are?
My lord, lordship, I can find it, page number 72, my lord. 72, my lord. '74. It says.
Notice.
With one submission, my lord. The petitioner has made the Director General of Police as the accused, my lord, who has nothing to do with this.
My lord, the direction is issued to the.
No, I'll just complete with my.
Lord, when.
Just one, to just make my, your lordship may see the first accused, my lord, and the principal secretary, home, my lord. The judgment, your lordship, 70, my lord. Is this ultimately, my lord, DG of police has nothing to do with this. He is a rowdy sheeter, my lord. There are 4 charge sheets against him in a building comprising of 7,000 square feet. He is running illegal activity of betting, my lord. Now, by issuing contempt against the DG of police and the Home Secretary.
Similar matters or that?
My lord, matters. My lord, recreational license, what happens, my lord? Like there's Bangalore club, various, this judgment, they run illegal gambling joints, my lord.
Correct. So, which?
Here, my lord, court officer.
So, order pass kiya hai.
87, 20,
Gambling. It is gambling.
Please, my lord.
So, order pass. Come on, next week. Some orders are passed.
Please.
Without entertaining the petition.
Please, I'll just see that.
With observation, it was disposed of. To find out.
My lord.
Several, more than one matter.
It's a false submission. Your lordship may kindly see. In the Gund Act, they had falsely implicated me in the Gund Act, my lord. This honorable court clearly observed that there is no skill is not illegal. Lordship may kindly find they had arrested and detained me in Gund Act just for running a recreation club, my lord. Lordship may kindly see page number 51, my lord.
So what is breached?
My lord, that is the order of the Gund Act.
Which of?
My lord, the direction is, there are several directions which says that
Which
police-
one?
My lord,
Which direction is?
Lord, in page number 72, my lord. in the
That we
writ
know,
petition.
but out of which? Because court says that
All
it
the
is
directions,
disposed of
conjoint reading of
in
the
the same
directions.
terms.
My lord, conjoint.
Petition is kindly listen. The
Please.
petition is disposed of in the terms of the order passed in some other matter.
Correct, my lord.
Now, which is the direction in that matter
That
which
is not-
applies to this case and committed breach of?
Please, my lord. My lord, there is the conjoint reading of this judgment shows that they should not interfere in smooth functioning of the game of skill, my lord. I have installed CCTV. There is a direction that I should install CCTV. I should allow only members only to play the game. Yes, my lord, I have been doing it. Now, my lord, your lordship may kindly see the photos I have produced at my lord, page number 111. They are not allowing, there are many police, they are not allowing me to enter the club. They are not allowing me to open the club. That is violation of the order of this honorable court.
Writ petition was disposed.
111, my lord.
Writ petition was disposed of. Writ petition number 34240 of 2024 came to be disposed of by learned single judge by order dated 16 December 24. Observing that it stands disposed of on the same terms as the order which was passed in our other writ petition number 8936 or 24. Dated 25th March 2024. Full stop. The directions contained in the said order dated 25th March 24, which was to apply to the outcome of the instant petition, contained the following directions. So quote from paragraph 75 to 76 bracketed portion. Paragraph. The first 5 directions are in the nature of obligations cast on the petitioner. Full stop. Question of committing contempt thereof does not arise, since they are the directions addressed to the petitioner, which would apply to the present petitioner as well. Full stop. In the paragraph, in direction number Roman small 7, Roman small 6, it is provided that the police shall have liberty to visit premises periodically on receipt of information. Full stop. This direction could not be complained of for their breach to bring it within the purview of contempt, since the police authorities are given liberty to act in accordance with law. Full stop. Direction number 7, Roman small, is that the respondent shall not interfere with the lawful recreational activities carried on by the petitioners, by the members of the petitioners club. Full stop. This direction also conforms the requirement of law and it would mean that if the unlawful recreational activities are carried out by the members of the petitioner association, the authorities are entitled to interfere with such to enforce the provisions of law. Full stop. The last direction in Roman small 8 is to clarify, is a clarification that the police will be entitled to invoke the provisions of the act in taking necessary action in accordance with law. Full stop. This is also a direction which requires the jurisdictional police to act in accordance with law.
My lord, liberty may be reserved to approach the single bench if they harass me or
Full stop.
if
The
they.
contempt petition is thoroughly misconceived. It is dismissed with cost of ₹5,000.
My lord,
To be
my
paid
lord,
to the.
it's a
There
clear
is no
case.
direction to be brought.
My lord, liberty may be
And
reserved.
we have
to
disposed
approach
of more
the single
than
bench.
3-4 petitions
And
on the same line.
What is interesting is, my lord, now people rowdy sheeter gunda want to
My lord,
attack the Director
they
General
have
of Police.
registered rowdy sheet purposefully only for the
I
reason
mean,
that
it's becoming,
a game of
my lord,
that's all.
there are 4
No,
charge sheets
For
pending.
5,000 to be paid before to be paid to the Karnataka High Court Legal Aid Services within 15 days. Full stop. It is
my lord,
clarified.
liberty to approach the single bench if they
Liberty
interfere.
liberty to the police authority to act strictly in accordance with law by taking all permissible actions against the members of the petitioner club if they are found to be indulging into unlawful activities. So, next.
Much.
For the complainant,
That's
I appeal for the complainant, my lords. In this matter, there's been a contempt of the order passed by the family court, my lords, dated 30/1/25. Notice.
This order is not capable of being implemented. You are a father,
I'm the mother, my lords.
mother.
So the mother was allowed to take the minor child to Jaipur. However, the father did not allow that on
For
some.
first at the Jaipur, subject to the health condition.
Yes, my lords.
So who will decide that who is in good health or not good?
Yes, they were supposed to conduct a
Notice.
test, my
So
lords.
this
None of-
event is over.
Yes, my lords.
So then what survives in this?
My lords, because there have been a repeated pattern where they're not allowing the child to meet the mother also.
This direction, read it. Is
My lords, it relates
is
to
it a
31/25, my lords. We were supposed, the order was
respondent is
passed.
permitted to take the minor son along with her to wedding ceremony of her first cousin at Jaipur. When it was held, wedding ceremony?
My lords, the wedding ceremony was in the month of Feb, my lords, from 5th to 9th.
The following is the order passed by first additional principal judge, Family Court, Bengaluru, comma, which is brought under the contempt jurisdiction of this court under the Contempt of Court Act 1971 by filing the present petition. Paragraph. The order in its operative part reads as under. Court
No
is
medical test was conducted, my lords. They were supposed to take a medical test. However, no test was conducted also, my lords.
well tail for this order to be quoted. Full stop. The order thus permits the respondent, that's the applicant herein, mother, to take the minor son along with her to a wedding ceremony, subject to the health condition of the son. Full stop. When asked about the date of the wedding ceremony, learned advocate, Miss so and so, the complainant stated that the wedding ceremony was scheduled to take place during the period from 5th of February to 9th of February.
Yes, ma'am.
Full stop. Admittedly, the event of wedding is over, long back, full stop. It was the permission was given to the mother to take the son to the said wedding ceremony. Full stop. At this stage, the contempt petition cannot be said to have been surviving. The court is not inclined to take any cognizance since the direction has become infectious due to efflux of time. Dismissed in the any of the above. The petition is dismissed in any of the above. Yes, next.
So it's number 14. Azhar Ali Faruqi.
If I filed
So
my
what happened
response
to
to the.
mediation?
They said they would convince the party to.
There is a trust deficit despite orders of this court. They didn't send the children last weekend, and what they send is an email. For Holy Festival, we'll not be able to send the children. I mean, if an order can be interpreted as a whim. And we had a hearing, just a day before this, we had a hearing here, and that was not mentioned to the court. And a unilateral decision is taken. I mean, due respect, my lord, kindly see. And I'm not just showing I'm just showing this for the last weekend. Every weekend, my client has gone through anxiety. Last time, a mail is sent at an untimely hour. My client flew down from Mangalore to eager to see his children on the weekend on Friday. And in the night, they send an email that they can't send the children because there's a school function. And a school function, and they didn't say what the function was. It was the graduation of the young boy. The father would have liked to be there. I mean, despite whatever differences, my lord, it has to be met in
May I
spirit.
place on-
I mean,
May I place on
and
record?
in the
Email
atmosphere where the party is the intention of the party is very clear to find reasons to fill out the order. And she doesn't compensate. She doesn't come forward and say, okay, you can come and take the children else some other time. The idea is to deny.
Plus, may I place on record a memo with documents, email communication? Every week the children have gone, except last week.
You're gone.
Every week, my lords, every week. I'm surprised at the submission made. Plus, kindly, my lords, may I just take your lordships through the email communication that I have produced. Plus, on 22nd, I say that the children can be picked up at 8 p.m. because they had a birthday party. However, he does not come on 22nd. Plus, thereafter, 28th. 1st of March on a Saturday, visitation is exercised. Plus, at page 10, my lords, in fact, they write, I have been asked to communicate to you by my client as follows. Due to uncertainty and lack of clarity after the email sent by you yesterday at 8:42, the children could be picked up only at 12 p.m. As my client has lost 2 hours, he has suggested that he will drop Anya at 4 p.m. and come in at 12 p.m. In fact, they have taken 2 hours extra because they could go only at 8 p.m. because of the event that was held, if I'm not mistaken, at the school, my lords.
Now, why want the graduation ceremony be informed to the father?
Miller's graduation ceremony was.
1 minute, madam.
The petitioner himself was well aware of.
1 minute, madam.
Submission made every
1 minute, madam. We are not aware of it.
Speaking, I don't think you should be interfering me every time, Millards. Millards, at page 11, March 7th. Good evening, madam. I've been asked by my client to communicate to you as under. As Kavin is unavailable until 2 p.m., the petitioner will pick up.
You narrated about this.
Email. Yes, Millards. Every week they have.
No. This is about December 24 and.
Millards.
Kindly see. I mean, I'm sorry, my lord. The intent, I can understand a genuine reason. And the intent to use reasons to deny.
What about the.
Every week.
1 minute.
What about the mediation?
Mediation, she is ready. They have not been. In fact, if your lordship said last time.
Why don't you try once? The tempers may cool down, the emotions may.
In fact, last time, your lordship recollects that the senior counsel did say that he will convince his party for mediation.
Right, depending upon their compliance with the order, and the next day they violate.
No, let they be before the mediator and have some.
We have always been ready. They have not been. He has never.
My instructions are that.
It's constant.
With due respect, my lord, kindly see, I'm not opposed to it. I'll be the last person to oppose a suggestion from the bench on mediation, and especially in a matter involving family members. But we've given it a long. We appreciate, my lord, the efforts of the court. And as counsel, also, we would obviously work towards that end. But this is a case where, my lord, I can demonstrate the intent is to deny the children the custody. In this atmosphere, it would be futile to have. And counts, due respect, my learned friend here, I don't know whether the client is obeying the advice of the counsel to follow the order and spirit.
Where you stated that every week they have gone.
Millards, I can demonstrate, Millards, in this 22nd.
I can demonstrate the violation. Let me demonstrate the violations first, and then she can defend.
28th, Millards. The order.
I'll just finish, my lord, and then she can respond. Kindly see the order. I'm sorry. Whichever my lord wants to hear her first, she can go.
Yes, madam. Where you are.
Millards, March 1st, Millards. First order was, Millards, on February 15th. In fact, your lordship had ordered that the father should exercise the visitation rights on February 15th, which was a Saturday.
What father is doing?
Millards?
Father is doing what? Who is doing some business?
Construction business.
Yes.
Construction business.
And you are housewife.
Millards, I'm a housewife.
He is an architect, but decided to while away time at home.
He can say with a 3-year-old child, obviously, she has to be at home. Let's March 1st, thereafter, Milots, March 1st at page 10.
First order.
Let's page 10, Milots, of my email communication.
No, 12th July.
Wherein they have said, due to uncertainty and lack of clarity after the email sent by you by yesterday at 8:42 p.m., the children could be picked up only at 12 p.m. So he picks up at 12 p.m. and the next day he drops the child at 2 p.m. Milots. He will drop Anya at 4 p.m. and Kavin at 12 p.m. tomorrow. This is what they themselves have emailed to me. Milots, March 7th, due to an event in the school, the visitation could not happen on March 7th. However, March 8th, it has happened, Milots. And that is at page, Milots will, I have not produced March 8th email, I'm so sorry. March 8th, again. Plus, except last week.
See, this is a contempt petition. This is a contempt petition. Because it's a husband and wife problem, we thought it can be resolved
Definitely.
if some better sense prevails on both of you. Now it appears that sense is not there. You're thinking of fighting,
Not
and you have got enough money to spend.
So she's always ready for mediation. However, he's not giving his
We are
consent.
not here up to those things. Once you have suffered an order, you have to obey it.
But she's been sending the children.
If you don't obey it, probably action will have to be initiated. That's all.
She's been
That's the
sending
only
every
thing
week,
that remains.
every week, except last week, because there was Holy Festival. That's it.
I mean,
Otherwise, she has sent Milots. I can produce more.
Whatever, have you obeyed the order or not?
Because just last week, because of the Holy Festival, I did send a mail saying that because of Holy Festival, there she is not able to send the children. And being North Indians, they celebrate in a grand manner. That is all, Milots. It was just last week she was unable to send because the children did not go. They wanted to play.
Both are North Indians.
Can be, Milots, that's...
I'm sorry, my lord, this is a
He's
complete distortion of facts. Holi was never celebrated in this household.
Indian.
They are looking for reasons every weekend.
I don't think they're...
I'll easily demonstrate to the court. A few emails are shown to the court and a picture is being tried to, impress upon the court that they are in compliance. I'm due respect, my lord, this is a family matter, but I can expose it.
Where are they from? Which native? They're natives of which place?
Who, my lord? We are Bangaloreans.
Husband,
Bangaloreans. Both Bangaloreans.
No, mother is not.
Nativity.
Basically not.
Native.
Yes.
Born and brought up in Bangalore. I mean, Bangalore is a cosmopolitan city. All of us are Bangaloreans.
His father is a
So
South
not
Indian.
that way.
Yes.
Here, Holi is not celebrated.
Not celebrated, absolutely. My lord is right.
They celebrate in a grand manner every year, in fact. Even the Deepavali Milots, in fact, the father and the family used to go to the mother's house to celebrate, which is in a grand manner. There are photos.
My friend should highlight to the court. 2 orders were passed for Diwali and Dasra, both of which were violated by my friend.
So my brother is rightly saying that you have to obey,
Yes, Milos, definitely.
Irrespective of reason.
Except last week, I myself am telling Milos, yes, last week, children refused to go because of the Holy
This is a talk which is not followed by action.
No, 1 minute. I don't think he should be interfering. I'll not be able to
Madam,
submit
I
at
have
all.
to tell the court that you are not talking.
Let him speak. I will speak
Yes,
later.
yes,
I will not interfere at all.
Every time the court suggests, the council seems to say that yes, but then on the...
Where is the original order?
Milos,
My
original
lord,
order
page
is-
number 34. And
correct.
I mean, we would We will hear this matter on merits, my lord.
Continue to obey this. We
Yes,
will
my lord.
watch,
No, that is the reason I have even stated in my
we'll watch your
response.
conduct for some time, and then if you're not obeying, then we'll.
I'm very grateful, my
No
lord. Very
intention of
grateful.
disobeying, my lord.
And
That's
my
one.
lord, my stand is that I will convince the court, but it's a family matter. Since the court, it's come from the court, my lord. The family sensitive matter, another opportunity to the other side. I don't mind.
Plus one condition, seventh, point number 7, the original order also says that the father has to pay the maintenance by 5th of every month in order to exercise his visitation rights, which has
We will
not been
satisfy
adhered.
the court.
Yes,
I've seen the
but 5th of
papers. I've
every-
seen the
I do
remittances.
not know why.
We will satisfy the court.
Speak at
The payments have been made fully. We will satisfy the court.
I am not able to know that.
We will show you, madam.
Plus I'm
We will show
talking to
you.
the court.
Where is
and
the
submission.
direction, payment of
Plus, that is at
6, 1,25,000,
page 34 of their contempt petition.
1,25,000,
Yeah.
only.
We are filing a memo of complete payment.
Plus point number 7. The further orders are passed till further orders are passed in the domestic violence case. By 5th of every month, if the
And
maintenance
my lord,
amount is
may I
not
submit
paid,
this
this
with due
order
respect? I
by
mean,
the court
she's reading the order.
visitation rights for that month, the petitioner and family
Two
cannot
submissions over there.
exercise.
Kindly see page
Plus
34.
point number 7, my lord.
So every month you are paying,
My lord?
every month you are paying.
Yes, yes.
Every month.
And my lord, the order is complied to the hilt. We have submitted a memo.
Learned advocate.
Not by 5th of every month, of course.
No, we will demonstrate. We will demonstrate.
I could also submit, my lords.
But my lord, holding back the children as ransom, that's not
Not at all.
permissible.
That even without payment, she's been sending the kids. I have just made my submission, that is all. Because their own memo of calculation speaks for itself. I don't even have to submit that by 5th of
My lord, if the matter is going.
any
for-
month,
if the matter
the
is going for
payment has
arguments,
not
my
been
lord,
made.
we will argue the matter. We'll see how the compliance on the next date of hearing, as my lord has suggested. If that does not happen, then my lord, I'll argue the matter.
Like I said, they are never in for mediation. That is the reason they have always said that. I
So
leave it to
this-
your lordships.
Visitation right is given for, in respect of girl, child, both two.
Both.
Yes, yes. The boy for
children,
overnight.
two
Every,
children.
every Saturday.
Yes.
Every Saturday.
And out of 100 weekends, 80 weekends have been violated.
Millards, they are talking about earlier. I'm talking about
Why
after your lordship-
earlier?
No, after your lordship-
Earlier, there's an exemption to her.
Yes, after your lordship directed,
The present contempt
every
petition.
week the children has been sent.
When the present contempt petition comes up for consideration in wake of the last order passed on 27/2/25. So my learned advocate, Ms. So and so for the respondent submitted. Responding to the grievance of the petitioner that the orders of the court regarding visitation rights are not being adhered to by the respondent mother, that it was due to celebration of holy festival in the family, that the children were not sent to the house of the father. She produces copy of the email communication in that regard. Full stop. The court is afraid whether or not complying the directions of learned single judge about visitation right every Saturday. Ground, much less. The above ground could be advanced in justification. If there is genuine difficulty, the proper course for the respondent in such eventualities, would be to approach the court to seek the clarification. Full stop.
Plus my submission
Having,
earlier, March 1st and March 8th, both the days has been sent.
it was
The children have been
stated
sent.
that the earlier weeks, the children were sent to the father's house and the visitation rights were accorded to the father in compliance of the direction. Paragraph. Having considered the subject matter and the aspects urged by both the sides, the court deems it fit to put off the consideration of the petition for some time and in the meantime, the compliance of the directions about the visitation right shall continue to bind the respondent. Mother, full stop. Stand over to, we'll say, let it be little 3-4 Saturdays intervene. 17th April.
April.
17th.
Full stop. At this stage, learned advocate, learned senior advocate.
Yeah, it's not
Learned
on the
so and so
on the queue.
Files documents by tendering memo dated 21/3/25 to submit that the petitioner father has discharged his obligation of paying the maintenance amounts every month. Full stop. It was submitted that the payment is evidenced by the copies of the check.
Plus by 5th of every month.
Produced along with the memo.
Very great.
The said memo is taken on record.
Very grateful.
Plus also the submission last time of the senior counsel who appeared that once the children are sent, the parties will go for mediation. I will make sure to convince the
No, we go by,
petitioner.
since the violation happened deliberately,
is-
that doesn't
your
stand
lordship
anymore.
had-
One more chance, we'll see on 17th, we'll
The
see.
beginning, in the last order, in the aforesaid order,
Yes,
it was recorded, it was
recorded.
the parties were required by the court to take instructions about their willingness to go for mediation since the dispute is matrimonial and concerns the welfare of the minor child. Full stop. The human element guided the court, human element in the issues involved guided the court to request the parties accordingly. However, today, learned advocate so and so was ready for opting for the mediation process to solve the issues, learned advocate Mr. So and so, the applicant stated on instructions that it is not possible for the applicant to undertake the mediation process as he is unwilling to.
That's up to. Great.
Still number 15. Servant.
For orders.
This was for what was to be done?
I'm seeking benefit of.
Just overlook the this is for extension of time.
No, so rule 12(1) FF, I'm seeking benefit of that rule.
What is rule 12? Rule 12 double F.
12(1) double F. It's force major, that denotes the clause.
Double F and double G.
Yes, ma'am. Yes.
So read it.
Plus double F, failure on the part of the lessee to fulfill any of the terms and conditions of the act and rules made thereunder or under the mining lease shall not give the central government or state government any claim against the lessee or be deemed a breach of the lease insofar as such failure is considered by the relevant government to arise from force majeure. In the event of any delay by the lessee to fulfill any of the terms and conditions of the act and rules made thereunder or under the mining lease on account of a force majeure, even the period of such delay shall be added to the period fixed by these rules or the mining lease. Notes in this clause, expression is explained. Last one, notes, any other happening which the lessee could not be reasonably prevent or control. Notes in para 14, I have produced the table.
What is force majeure?
Notes in this case, notes I have explained. I didn't get the order simultaneously from the Department of Mines and Department of Forest. I produced it in the table and I showed your lordship notes in para 14 of the appeal memorandum. Para 14 of the appeal minutes. Lordship had to see minutes. The orders minutes, the under 12(1) GG, 6 months time was given by the Department of Mines and Geology on 16/9/2023. That is up to 19/3/2024. Notes, but Forest Department notes they gave permission only on 4/12/23. And the permits notes permission was given only on 7/2/2024. By that time, notes the time which was given was already spent out. And again, notes the next table notes 12(1) HH.
The permission issued by the mining department for a period of 1 month on 23/2024, but forest departments, they give the permission only on 12/4. And the ILMS was unlocked only on 12/4/2024, and permit was issued on 16/4/2024. And release order for transportation was released on 18/4/2024. Left with only 2 days.
So double H and double
G, double G, and I'm
What is-
seeking benefit under double F.
you are seeking benefit of double F.
Double F, no.
So we'll consider in light of this provision, that's all.
My lord, we have given them the opportunity both under, my lord, section, rule 12(1) GG and rule 12(1), my lord, HH. That is for 6 months and then an extension of 1 year, 1 month. My lord, since that had not been obeyed, my lord, considering that the government becomes the owner of the property, my lord, we have said that it is not possible, my lord, to grant them any further extension of time.
Where is that extension given?
No, the table which I produced notes itself notes, that is the table which I produced.
Produced it
TG,
in an
HS.
extra R1 and R2, my lord, to the statement of objections filed on 8/7/2024.
See, his contention is both forest and mines and geology department are required to give the necessary permission. Then only he can lift the material, not otherwise. He says first mines and geology, there was no synchronization between these two permissions. Because of which he had no time to lift the material. Is it true?
My lord, assuming but not admitting it is true, a coordinate bench of this honorable court, my lord, in WP 14212 of 2020, which I have produced as annexure R3, my lord, paragraph 13,
Yes, you last time.
14, yes.
Correct.
But in that case, not para 9 of that order.
Let us submit.
Let us one by one. We'll see both.
Not para 9 minutes in that order.
There are 9.
The earlier petition, petitioner never made any grievance about the delay on the part of the senior geologist in submitting the report.
But then the court says even if there is a delay, even if there is something.
But that is the reason,
something-
Lords, that is
some-
that is the reason I'm requesting that this case should be considered under 12(1) FF.
There is no power to extend beyond 6.
No, yes, my lord.
Lords,
No power.
That's the point.
Yes.
but 12(1) FF, Lords, that benefit.
They
Lords.
granted twice.
Yes, my lord. 6
6
months
months
and
and-
then 1 month.
1 month.
1 month further.
Yes.
Para 13 and 14 ratio, that affects it.
But in this case, Lords, 12(1) FF was not considered. I'm only seeking, Lords, requesting this court to give me benefit.
Sorry,
under-
dismissed. We have to follow the binding precedent.
Obliged.
In today's date, it will be in today's. You'll get the order on Monday or Tuesday. Yes.
Seal number 16.
I appear for petitioner, Your Lordship, on this matter.
I appear for respondent number 4 minutes. For respondent number 2.
For respondent number 10, madam.
Who is the petition?
I appear for petitioner, Your Lordship.
Yes, what is it about?
Your Lordship, this writ petition is regarding the potholes in the Bangalore, Your Lordship.
Pardon?
Potholes in the Bangalore, Your Lordship.
Every time they give me petition, patients, which I don't know what happened in the.
You file your affidavit, madam. 22/11/24. Yes, you want to argue or some other day?
Your Lordship, respondent number 2 has to file the affidavit as per the last order, Your Lordship. Further affidavit.
BBMP, my lord.
BBM, yes.
After preparing the affidavit, we need one more time to just complete the formalities, my lord.
When do you want? At the request of Learned Roger, Miss
Pranjali.
Pranjali for respondent BBMP in order to enable the BBMP to file its affidavit as recorded in order dated 20/28/25, stand over to. When, madam?
1 more time.
1 week's time. So 16th of April.
Obliged.
16th April.
Obliged.
Yes. But do file before that date because the 2015 appeal, petition of 15.
Seal number 17, 18 are urgent. Seal number 19.
My lord, this pertains to constitution of the Civil Services Board. my
I
lord.
appear for the petitioner, my lord. May I just make one request, my lord? My lord, would your lordships kindly have a look at the order, please, my lord?
My
My
lord,
lord,
the
the issue.
subcommittee.
May I just complete what I'm? May I just complete what I'm saying, my lord?
We are
Like, would
aware
you
we are aware
But-
about the obligation on their part. You do it, otherwise we have to.
My lord, may I make one submission? My lord, the subcommittee had its first meeting, but for the second meeting, my lord, due to the assembly being in session.
You put
my
it
lord,
in.
Very well, my lord, may grant me 2 weeks, my lord. I will see
My
that.
We will not grant 2 weeks. We grant, if you want to file reply, showing your conduct to file. Otherwise, this is Supreme Court direction, not complied with since how many years?
My lord, the first judgment of the Supreme Court, my lord, was at the page number 69, my lord.
And there
I'm
is no
sorry, 72, 2013, my lord.
My lord,
October
the
30.
statement of objections have been filed, but a submission was made by the Learned Advocate General that the subcommittee, my lord, had been constituted, my lord, to examine the functioning of the board. My lord, the subcommittee had its first meeting. My lord, because of this, my lord, intervention, they couldn't have the second meeting. My lord may grant me a period of 10 days time, my lord. I'll get back to my lords.
My lord, in fact, on the last date, your lordships have directed them
We'll
to
say
put the status report in writing, my lord.
At the request of Learned Additional Government Advocates, Nilo Parakpar, the petition is ordered to be listed next on 17th of April. 17th April.
Yes, I'm obliged.
Full stop. On the next day, unless the concrete stand is taken about the steps taken towards concrete steps are shown. Concrete steps are demonstrated before the court in respect of the steps taken by the state government for formation of the Civil Services Board.
Yeah, my lord,
Please.
functioning of the Civil Services Board. A committee has
Formation.
been constituted to examine the
State Civil
functioning.
Services Board. State Civil Services Board, in view of the decision of the Honorable Supreme Court in Prakash Singh, same.
TSR Subramaniam.
Same, Prakash Singh.
Yes, my lord. Prakash Singh TSR, as well as a judgment of this court.
2006-8, Prakash
Yes.
Singh versus Union of India, Interim 2006-8 SCC, page 1. Stand over to 17.
I apologize, man.
Great.
This is writ appeal matter. Seal number 20. P. Sudhadi.
Hearing on behalf of contesting respondent in this matter, lords.
You are for appellant. Will go a little longer.
There's no urgency in the matter, my lords.
No urgency.
No, certainly no urgency in the matter.
It will go after now, on the reopening,
Lordships,
4th June,
please.
as requested. Send out to 4th June as requested.
21 is adjourned. Seal number 22. Rohan Usmat.
Appeal, my lords, against the learned single judge's order. I was arrayed as respondent number 8 before the learned single judgment.
It is only remitted.
Yes, ma'am. Can I just explain? It's a very strange sort of, if my lords give me 5 minutes, I'll explain. It's quite strange that the petitioner even approached this honorable court. I'll explain why, my lords. In short, what has happened is there was an original survey number 18, which came to be podied, survey numbers 18/1, 18/2, 18/3, not relevant really for this purpose, my lords. Then 18/3 further came to be podied, a portion of which, my lords, the writ petitioner, who is the contesting private respondent herein, my lords, purchased a portion of that property and got it repodied again, my lords. Now, if my lords were to kindly mark 2 dates, the first podi was done, my lords, on 30/10/2006. Second podi was done at the respondent's behest on 16/3/2007. In the interregnum, my lords, he had purchased the property. I have no issue with him actually whatsoever. Now, my lords, what is pertinent to note, my lords, is the portion of the property that the respondent purchased got further bifurcated at his behest. It became 18/5. I have no claim on 18/5. There is, I can state that on record. Subsequently, my lords, in 2011, I purchased 2 items in 18/3 and 4. So 18/5, no dispute regarding the respondent's ownership. I purchased portions of 18/3 and 4. Now, interestingly, my lords may kindly see, this is where the dispute starts. See, page number 157. 8/12/2016. Page 157. I write, my lords may kindly note the date of this. This is 8/12/2016. About 5 years after I purchased the property, there's never been any dispute with the respondent. Kindly see the second paragraph. We propose to construct a building in the said land. In the village map, there appears to be a drain through a corner in survey number 18/3. Therefore, we request you to kindly conduct a survey and identify the exact position of the drain, and also let us know the extent of the buffer required to be left. So it was purely a request to the ADLR to tell us where this nala is, so that I can construct accordingly. Kindly see what the ADLR does, my lords, at page 159, the translated copy. About 6 months later, my lords, in June 2017, he writes to the Joint Director of Land Records at page 160, my lords. I'll directly come to the relevant portion.
159.
Page 159, running on to page 160. Kindly see the last about 4 or 5 lines at page 160. He records that the report and documents of reference 1 have been examined, and the entire file has been submitted seeking for orders and consideration for the purpose of registering a suo motu appeal. Because I asked him to conduct a survey to record, to tell me where the nala is. He requests the Joint Director to register a suo motu appeal. Then, my lords, the next step is what the JDLR does. At my lords will find at page, kindly come back to page 59, my lords. 59, annexure C. The Joint Director registers a suo motu appeal. First of all, my lords, there is no power to register any suo motu appeal under section 49. And then, interestingly, that is when the respondent, the private respondent, is brought into the fray. Not at my behest at all. I have, if my lords recollects, I requested the assistant director to survey 18/3.
Which assistant director registered suo motu?
No, assistant director requests the joint director to register suo motu. Joint director, as per the request, register suo motu.
For what purpose?
Precisely, for what purpose? I asked, please tell me where my drain is. Then he registers a suo motu appeal and then redirects a podi of the erstwhile 18/3. Now, interestingly, my lords, the private respondent is made a party. From the record, it is not clear whether he even contests, because very frankly, my lords, he's not affected by it. 18/3, a portion, my lords may recollect, 18/5, I have no claim over. So possibly, understandably, he does not even contest it before the joint director. The joint director, my lord, sets aside the podi done in 2007 and says, re-podi the entire thing. So I approached, then, my lords, I approached the deputy commissioner. My lords may kindly say, I'm sorry for jumping again. Page 59, my lords may kindly come to. Kindly see at page 59 who the respondent number 4 is. That is the respondent herein, the private respondent. And then the joint director notes, a suo motu appeal under section 49F of the Land Revenue Act has been registered.
And what is about this 18/5 is belonging to whom?
18/5 is very much the respondent's. I have no claim over 18/5. So therefore, in fact, my lords, the private respondent should be supporting me because by virtue of this joint director's order, even his podi is now been entirely reopened. Nobody requested, and more so, my lords, even assuming there is a power and this power is wrongly exercised under section 49. Under section 56, my lords, there's a 3-year limitation. The podi was done in 2006 and 7. Could it have been done, my lords? I asked myself in 2017 and 18. So on those grounds, my lords, the deputy commissioner sets it aside. Frankly, my lords, I think the private respondent should have been happy with that. He approaches the learned single judge. Learned single judge remits the matter for everyone to be heard, which is what we're agreeing. My lords, a small request has been blown out of proportion. A re-podi, which we never requested, has been ordered under a non-existent provision, grossly barred by limitation. And that's what the deputy commissioner seems to have held, my lords, that the podi could not have been redirected. Sorry, a re-podi could not have been directed.
Yes, what do
Let's, I'm representing respondent number 1, who was the writ petitioner not before the learned single judge. The issue has commenced, as learned senior counsel has said, pursuant to their request for identification of the drain passing through the land belongs to the appellant.
But how you are concerned with that?
I'll submit.
There is no.
No, the original survey number 18/3 consists of about 15 acres.
You are the purchaser of
18/5.
When you purchase it?
I purchased it in 2006. Six. The reason for initiation of suo motu proceedings is that there is a Karab land in the entire extent of 15 acres, and which is distributed among 4 sub-survey numbers.
A Karab or B Karab?
B Karab. It belongs to government. Since there was a discrepancy in distribution of Karab land in respect of each of the sub-numbers, the revenue authorities found, pursuant to the application filed by the appellant, that your lordship may kindly see page 158, which is the report of the ADLR submitted to the joint director, deputy director of land records. It is for the reason that the distribution of Karab land in various sub-numbers is not correct. Therefore, it has to be redone. On account of redoing the entire exercise, none of us are going to lose our lands. There is no chance of reduction of the extent of land which we are holding. What the government now is doing, the revenue authorities are trying to do is proper distribution of the Karab land in the entire extent of 15 acres, and which is subdivided into 3 parts. If the entire exercise is redone, none of us would be having any difficulty. The reason because if the petitioner would
size of remeasurement.
Yes, remeasurement and
Poding, at that time, re-poding, they made redraw. Of course, it is for the government to say that. I asked myself, the government itself allowed my revision.
Even if they remeasure or redo the poding.
Well, let them complete it within. I'm sorry.
It will not affect your title.
In the guise of that, now kindly see the manner in which this has happened. I asked them to identify a drain, a nala. Now, from this, exercising a non-existent provision, should I be put through the process about 11 or 12 years after the previous podi was done? If the power is there, certainly they can do it. And kindly see, the writ petitioner was in no way affected because he was no one interfered with his possession. He didn't interfere with my possession.
But they
So therefore, the whole remand becomes a futile exercise.
Where is Annexure E?
Annexure, I'm sorry, Manoj.
E. Annexure E order dated 3/6/19.
3/6/19, yes. That
Which
is
is,
at, I'll just
which
point
is
out,
set- which is set
page
aside.
81.
Page 81.
Page 81. The
I have not been arrayed as a party in these proceedings, though I am this adjacent
page
landowner.
84. Manoj.
Yes.
What was the need to this?
To challenge, that was all little surprising, Manoj.
At
What
your
is-
instance.
Correct, this appeal is filed by the
writ petition.
Writ petition has been filed for this reason. Kindly see the original order of the Deputy Director of Land Records. That is at page 56, Annexure C. Translation is at page 59.
You are August Ventures.
Yes, I'm August.
Kindly see,
You are not party before the Revisional Authority.
Before the Revisional Authority, I should have been arrayed as a party.
You are not a party.
They have not arrayed me as a party.
You file a petition.
I file a petition, therefore.
File a petition.
Yes,
You should have confined to your grievance to 18/5 only.
When a larger extent of land is supported into 3 parts, my grievance is considered to 18/5, I have no objection. Let the survey authorities conduct survey and podium in respect of 18/5. Kindly see for a moment.
If you want your land to be remeasured, do it.
No, I did
can't come in the way.
not.
Absolutely.
I did not ask for it. Kindly.
No, you want your body to be reconducted in respect of 18/5. Let the remand proceedings go on to that extent.
May I make one request? Kindly see page 57. Page 58. The order passed in a suo motu proceedings.
We do not see you point out any rational reason why they should undertake this exercise.
That is what I am pointing out. From the original order passed by the Deputy
How
Director.
you are concerned with their land and the body to
Please,
be conducted for their land.
Please, I'll point out.
Because we are not able to understand what is your interest.
No, I didn't.
Your
And also,
interest in getting the body conducted again in which was purchased by 2011.
It is not at my request, the proceedings are initiated. It is at the request of the appellant, for finding out the drain in the larger extent of land. The drain passes through in 3 subnumbers. The body cannot be confined to 1 subnumber. It passes through 3 survey numbers. And after this order is passed, in their favor, they went to the Deputy Commissioner and they got the nala shifted on the periphery of my property to avoid leaving 30-meter buffer when they construct. Now, on account of shifting of nala just adjacent to my property, obviously I have to leave 30-meter buffer, which they were supposed to leave. Therefore, this order has a far-reaching effect on my rights. Kindly see what the original authority has done. Kindly, only three sentences which the original authority has pointed out for conducting of resurvey and body. The translation may not be correct. At page 63, the sum and substance of the resurvey and repody is to this effect. To issue notice to all the kata holders, take note of the extent mentioned in the documents of title, compare boundary of sale deeds, partition deed if any, and conversion orders, measure the land, distribute Karab appropriately, and carry out hissa podi durast. For this reason, this suo motu proceedings was initiated, this was directed. Before the revisional authority, their grievance was, we were not heard in the matter. The same principle applies to me when I am an adjacent landowner. Should they not make me as a party when they file appeal before the Joint Director of Land Records? The learned single judge has not decided anything on merits. It only said go before the original authority and let the original authority conduct fresh inquiry and pass an order. Your Lordship may kindly direct the original authority to do it within 4 weeks. We will fully cooperate. Nothing is going to harm the other side.
Can he be permitted to piggyback on an application filed by me? All that nala being shifted, that's not in the pleadings, so I'll ignore that. But on an application to identify nala, let them identify the nala because it's my request, at my request. But in the based on our request, now he's piggybacking on a small request to have the entire survey number reported. That is only my submission that can't be done. In fact, he says his grievances he was not heard. Before the joint director, when he was arraigned as respondent number 4, the records don't show that he even contested it.
No, I was not
a respondent.
No, I was not issued with a notice in the original proceedings also. I was not heard in the matter. Even before the revisional authority, behind my back, they want an order to their convenience. And based on the order which was impugned before the learned single judge, they approached the deputy commissioner and they got the nala shifted to my property.
Only thing I asked myself was, what is the order that is to my convenience? The impugned order which he challenged before the learned single judge was an order setting aside the reordering of Podi. So what my learned friend wants is a revival of the order directing reporting. That can't be done in an application filed by me. I filed an application. How is it to my convenience? In fact, my original request is still not considered.
The distribution of Karab land in 3 sub-numbers should be in accordance with the village map of 1967.
He can always file an application.
What made you to challenge this revisional order?
Correct, that's what.
The reason because the original authority has said to do all these things. That has been set out not by the revisional authority in my absence.
The authority said that revision is allowed. The impugned order passed by it is assistant collector, assistant director.
Yes.
In case number so and so set aside. So that order was of conducting of
report.
At whose instance?
At nobody's instance. I didn't ask for it.
Suo motu.
Suo motu for the reason the distribution of Karab land is not proper with the findings of the revenue authorities. The Karab land belongs to government. If distribution is not in accordance with law, therefore the government has got power.
Quietest to this.
Heard learned advocate, senior advocate Mr. Vikram for the appellant and learned advocate Mr. learned additional government advocate Mr. Raghavendra for respondent number 2, 3, and 4. The state and the authorities 2, 3, and 2 to 7. The state and its authorities. And learned advocate Mr. Vivekanand for original petitioner, respondent number 1. Hearing. The appeal is directed against judgment and order. The appellant is the original respondent number 8.
Yes.
In the petition, who has challenged the judgment and order of learned single judge dated 23 July 24, whereby after setting aside order dated 3/6/19 passed by the deputy commissioner in revision petition number 10 of 2019-20, learned single judge has remitted the matter to respondent number 2, the deputy commissioner, for reconsideration of the issue afresh. The attendant facts paragraph in the background to be relevant to comprehend the context of the order of remand, deserves to be noticed. The appellant herein purchased land survey number 18/3 and 18/4, situated at where?
Which village? Which village?
That's Kalasanadli village, Kyapuram Hobli.
So and so, Hissa, no. Kalasandra village.
Kalasanahalli.
Bangalore East. By registered sale deed executed in its favor in the year 2011. Full stop. It appears that the appellant wanted to construct a building on the said land. Therefore, an application dated 18/12/2016 into bracket copy figuring at page 157 annexure L bracket over was made to the Assistant Director of Land Records, requesting the authority to conduct a survey, to identify the exact position where the building could be constructed. Full stop. It appears that this application triggered a suo motu action by the Assistant Commissioner, who exercised suo motu powers under section 49 of which act?
Land
Karnataka
Revenue.
Land Revenue Act.
Karnataka Land Revenue Act.
Pursuant to the report of the ADLR.
Correct.
And passed the order of, what is that order?
812, that's at page 59, Manoj.
Passed the order,
Annexure C.
page 59. Passed the order allowing the suo motu appeal and duress in respect of survey number 18/3, 18/4, and 18/5 in question was directed to be conducted. Full stop. It may be noticed that it may be stated that land survey number 18/5 belongs to the
First
petitioner
response.
before the law in a single judge. Full stop. It is extremely doubtful in law whether the Assistant Commissioner was competent to exercise any suo motu powers under the aforesaid action. Be that as it may. Also, that aspect is not gone into at this stage. When the court is dealing with the aspect of admission or otherwise, and grant or otherwise, admission or otherwise of the appeal, and grant or otherwise of the interim relief. Paragraph. The aforesaid order of the Assistant Commissioner,
Assistant Director of Land Records.
Director of Land Record, not Assistant.
Joint Director of Land Records.
Was taken in revision before the Deputy Assistant Director of Land Record.
No, Deputy.
Bengaluru North Division. The aforesaid the order dated
Page 81, man.
was taken in the revision, which was allowed by the Deputy Commissioner as per the impugned order, as per the order dated 3/6/19, which was impugned in the writ petition. Full stop. Noticeably, full stop. In the revision proceeding, comma, the petitioner before learned a single judge was not a party. Full stop. Its land was survey number 18/5. Full stop. However, said respond number the said petitioner challenge the order passed in the revision application. Full stop. Learn a single judge set aside the order and remanded the proceedings to be considered afresh. Full stop. Learn a senior paragraph. For the appellant would submit that neither there was any good reason in law for the authorities, namely the Assistant Director of Land Records, to exercise suo motu powers to undertake the body afresh, nor, comma, any reason was furnished for conducting of such body as is observed by the civil authority. Full stop. The court fails to understand as to what motivated the Assistant Commissioner of Land Records to act under section 49 to pass the order. It is also not comprehensible, prima facie, as to what subsisting interest the petitioner, respondent number 1 herein, has in prosecuting the order passed by the reviewing authority when, his land is 18/5 and there was no reason even otherwise to undertake the 40 of land survey number 18/5. Full stop. Prima facie paragraph. The order of law on a single judge to remand the proceedings in respect of survey number 18/3 and 18/4 does not stand to reason either in facts or in law. Full stop. In that view, the following order is passed. The appeal is admitted to the impugned judgment and order of law on a single judge insofar as it remands the case shall remain stayed to the extent that it seeks to remand the matter for conduct of Kodi and Durasti in respect of survey number 18/3 and 18/5. For you, you can full stop.
He can work out.
The remand, the authority is not precluded from going into fresh.
In
Durasti
the absence
Kodi-
of not
Kodi in
inquiring
respect
into
of the
the
land survey number 18/5.
Grateful. At the time of conducting the survey in respect of 18/3, let the survey authorities hear me.
23 is adjourned. Number 24, Mr. Narsimhaya K. 24.
Yes, Mr.
This is an appeal against the order of the learned single judge.
What is the order?
Order dated 31/7/24.
What is wrong with the order of learned single judge?
This is a grant. I am the adopted son of the original grantee. The land is a grant land, granted land. And with the condition that there is a non-alienation clause in the grant for 15 years. During the currency of the prohibition period, the will is said to have been executed in favor of the respondent number 4, as per the act and as per the order of the grant also. The will cannot stand, and therefore the two appeals are pending, RSA, wherein they are admitted and a substantial question is framed with regard to whether he is the adopted son, that is myself.
But
As
in
in
that
my-
regard, the respondent suit is decreed, appeal is dismissed. Now you are seeking the writ petition not relief. Contrary to the relief granted by the civil court, you want to set aside that position?
My lord, basically the will cannot stand.
Basically, yes. In effect, that is the position.
Because
You
will,
want to overcome the decree passed by the trial by the civil court, confirmed in the appeal, in relation to what? Property number 56/9.
yes, 2 acres. In fact,
How can the writ jurisdiction can be exercised?
my lord, page number 25 of the
And the
appeal.
appeal is pending, your appeal is pending?
Yes, my lord,
Then
that is second.
Your appeal is pending.
Second appeal.
Where the issues are framed,
Yes,
which will be decided on evidence.
they are
And that is the very subject matter of this petition.
yes.
Then dismissed.
My lord, commission-
All, everything you are saying, yes, so what else?
my lord, the appeal, substantial questions are there. Page number 25 may kindly be seen.
Page number?
Whether court.
But what we asked is right or not?
Please, my lord.
That much you say yes.
My lord,
What we asked you is correct or not?
2 acres total extent.
No, you answer. The questions we asked to you just before are correct or not? Questions are correct or not?
The
Questions we asked on the basis of facts and the findings recorded by learned single judge are correct or not?
my lord,
Questions are correct or not? We are not on answers.
yes, it is,
Correct, all.
they are not correct because,
Not correct.
no, my lord,
You are committing contempt of the court.
my lord, the trial court as well as the appellate court has wrongly dismissed the, has given
What was the prayer in the petition? Let us.
petition, writ appeal. Yes.
Further
Set
proceedings.
aside the order of the learned single judge. Allow the writ appeal. Pass
DCAC order and confirm the order passed by the Deputy Tahsildar.
Council, the dispute pertains to a land, piece of land.
Please.
Now, civil court in OS as well as RA, it went against you. It has been held the other person is the owner of the property concerned. Correct? You have challenged it in RSA, which is pending.
Please.
No interim orders are passed in your favor. Based upon the order passed in the original suit as well as in the first appeal, he made an application to the revenue authorities concerned to mutate the revenue records in his name.
Yes.
Automatically, it has to be mutated into his name. Now, revenue documents are not document of title. Two courts concurrently has held that he is the owner of the property. That order is not changed by this court yet. Under the circumstances, he is entitled to have revenue documents mutated in his name. Tomorrow, if you succeed here in RSA, automatically you will have a right to have it mutated into your name. Now, what mistake can be found in the order of the learned single judge who has recorded the same?
The basic question to be canvassed before this court is whether
This is not a title to suit, sir. This writ petition, we are not getting into title. As on today, the competent civil court has held him to be the owner of the property concerned. On the strength of it, he is entitled to have the revenue documents mutated into his name. That's all.
But the fact that it is a granted land has been totally missed by the civil court, by both the courts.
Your Lordship, on submission, we are in position since 24 years. And the petitioner is a granting.
Sir, say that in RSA, sir, not in these proceedings.
So the condition is there 15 years not to alienate or give will. During the pendency of the grant.
Will is not alienation as contemplated.
Will is not maintainable, even not registrable, but registration is taken. PTCL.
In fact, the PTCL Act also very much clear. This court is very well aware of the fact.
PTCL Act, Your Honor, there are so many conditions in the PTCL Act. Even sub-registrar should not register it without the grant condition, not violate. So there are so many conditions are there, not to prohibition for registration of a transfer of a granted land and prohibition of a transfer of granted lands. Permission is necessary. Without that, the old age person will has taken, will for 1 acre. But civil court is barred by PTCL Act rules. So the PTCL order passed is error. And also, we are in position since several years. The court is not considered. So the civil court is barred by jurisdiction of the will regarding the granted land within the period during the pendency of the period transferred. So we are in enjoying, but yes, Deputy Tahsildar has granted kata in our name, petition name, and filed before AC and DC not considered, agreed by that order, writ petition is filed, stayed. So writ petition is not considered in the revenue documents and everything. And also the OS 91/95 petitioner and granted father, adopted father, compromised in the civil court. After death, the property must go. So the violation of the 13 class 1/6A not maintainable to get will, because already civil court OS 91 page number
compromise.
OS 91 ordered compromised between the parties, because the adopted son, yes, the issueless person, Venkappa is the granted land in his name. He's a issueless person. He's adopted as a son. He was look after this thing. And on the condition, after death also property is to go to him. He cannot be transferred as a will. And civil court order is 91/95. order is there. That order has to set aside and get will is correct, but not set aside and suppressing the matter and getting will is incorrect. So we are in question since 44 years, 24 years, RTC goes very commercial crops, tea, food and everything. So till they dispose of the two cases of RSA, stay may be granted. They have to consider that. Not only I came through RTC, I am genuine documents and PTCL Acts violation registered, even your lordship, prohibition of the registration of a transfer of granted lands, nothing, anything in the registration of the Act 1908 on or after the commencement of the Act, no regarding the officer shall accept the registration of the document. Registration of the document will modify granted land, the grant certificate is there. So in such circumstance, stay may be granted to avoid, and if the party, the petitioner died is legalized or their 5 members, their life and they grown the trees, he will take away. So violation of the authority of the registration of the PTCL Act is also wrong. On the all the basis, 2 cases are pending in RSC and the outcome of this. But order was passed by the oral order, not a genuine stated. So if it is passed by petition, is as a genuine, not order. Oral order may be considered and stay may be granted to safeguard the interest of the petitioners to ground. Their title is not perfect. They have to take will probate as not obtained. So, and also civil court is not right regarding the SC/ST Act prohibition. So on these facts, kindly stay may be granted till disposal of the 2 cases.
You want to argue? You want to argue? Then argue. Do you want to argue? We're asking.
Subject. Subject to the outcome of RSA.
So the 2 petitioners and 2 advocates, or we have failed to understand.
He is not able to.
No, not difficult. So you want to argue? We are asking.
I 3 filed all the documents of RTC.
Additional documents are also filed. He wants to represent that because of the additional documents showing that they are in possession of the property by way of revenue documents. He wants to get the protection and get an order of stay because the fact that RSAs are pending. So till then it may be stayed because he is hard of hearing now. He is not able to. So therefore he took his
No, he said in the course of argument, it's a oral order, so it is not valid.
No.
No, he said that, right?
Please, I know he told. No.
But now you listen to our oral order.
No, well, oral order also is effective.
Oral order on the basis of
The single judge has passed a oral order. You should
We
not.
are also passing oral order.
But sorry, they know PTC like that.
Lord, the ownership of the petitioner is subject to the
You also
outcome.
want to argue?
No, while
After this much exercise. So whom should we trust about the wisdom?
Lord, only submission is.
No, you want oral order or? No, nothing to.
It is
No,
not my
kindly tell, you want us to pass oral order or you want to pass? No oral order.
It is not my submission.
No, we will not pass oral order.
It is not. It is a submission of the other.
No, we are not going to pass oral order, reserved for all. Reserved for orders.
Lord, it may be disposed of.
So heard learned regular so and so, with learned so and comma, learned additional government regulation, Rajshekhar, Chandrasekhar, Naveen Chandra. For this one state and learned regular Mr.
For the respondents, my lords. Fourth respondent, my lord.
Fourth respondent at length.
Yes, my lord.
The party stated that the learned party stated that they argued the appeal. Finally, they further stated that no pleadings are required to be, pleadings are complete and no further are required to be added or supplemented, reserved for judgment.
No, it may be disposed today, sir.
No. We don't want to pass oral. We say heard at length. You must get what is due to you.
He is a little hard of hearing, therefore.
But
Yes, he's
all
little.
are welcome. We are not saying no. Most welcome to argue, but at reasonable length, not. So we are reserving.
My only point to be canvassed is
You want to give the written submissions?
no,
Oral. Oral you don't approve, therefore you also give written submission. You want to give, then you give by Monday.
only one point to be canvassed is once the grant order is there, it is totally against PTCL Act.
Now we will not permit you to argue, Mr. Once having reserved. If you want to give written submissions, give. Now no more wasting of time. You can't go on arguing like any length. Yes.
Because he took
Yes,
my
ma'am.
help, I came out.
Since we are in lighter mood, that doesn't mean that we are not countenancing your.
No, man.
Yes.
I'm.
Yes.
25 is adjourned. Serial number 26, Mr. Nayak VS. 26.
26, yes.
For the appellant, man.
Your employer. No, your workman. So what is it about?
Delay of 56 days, my lord.
Delay. Delay. Who appears?
No, man.
Notice.
Yes, it is served, but not.
Wait for. Give copy to the counsel who appears on panel of the. We'll keep it on. When shall we keep? 2nd April.
So,
2nd April. In the meantime, copy of the appeal and the delay condonation application shall be served to the counsel for the Karnataka State Road Transport Corporation who appeared before learn a single day.
Serial number 27, Mr. B. Ramesh.
Appear for 12th respondent.
Delay is loss of 72 days is there in filing the appeal. The delay is 72 days, my lord. Notice has been served on all the respondents.
You are objecting or we are from?
Maybe condoned, my lord. Merit may be considered.
Is condoned or not condoned? It is already condoned.
Yes.
The civil suit is starting with.
It is already condoned. So what is the update?
My lords, the order passed by the learned single judge, my lords, directing the revenue authorities, Tahsildar, to mutate the name of the fourth respondent. My lords, the petitioner, the respondent in the revenue records, my lords, in the RTC in respect of the property in question. My lords, this property was alienated by the respondents herein in favor of the appellant herein, way back in the year 2010, my lords, annexure G1 at page 239. My lords, this property was a residential property which has been alienated, my lords, in the year 2010 by the respondents herein, my lords. My lords, the Kata was also transferred by the jurisdiction Gram Panchayat. My lords, subsequently, after the alienation is taken place, my lords, I have put up a construction, I am residing there. My lords, the very same respondents once again alienates this property in favor of the 12th respondent herein on 2014.
This suit 966 of 19 is by you.
Filed by 12th respondent.
12th respondent,
Myself.
12th respondent.
Is for declaration.
What is that suit for?
The suit for declaration.
Declaration.
Yes, even the appellant is also party to the said suit.
At page 264, my lords.
So you are the original petitioner.
Plaintiff.
Plaintiff.
And the petitioner also.
Yes, in the
Yes, my
petition, my
lords.
lord.
So what was the order of the deputy commissioner?
My lords, to remove the name of the petitioner, the petitioner, the writ petitioner. My lords,
Then
the,
that entry may remain subject to the outcome of the suit.
That's all.
my lords, what?
That
my
is the
lords,
order
what
of
has
the.
happened? My lords,
That is the order of learned single judge also.
Yes, my
my
lord.
lords, what has happened? My lords, I'll
His
submit,
right is
my lords.
protected.
My lords, I'll submit. My lords, this land is not an agricultural land. My lords,
That is subject matter of suit. Why do you forget it?
my lords,
When the
because,
parties are at civil court disputing their rights and agitating rights in respect to the property, then mutation, if at all to be there,
my lords, mutation, my lords,
has
it-
to continue, but
Yes.
subject to outcome of the suit. And then in such ground, the writ court has no role to play.
my lords, yes, my lords. My lords, here what has happened? The land has been converted, my lords. It is the residential property, my lords. My lords, the kata has been mutated by the jurisdiction Gram Panchayat, not by the Tahsildar. My lords, he purchases a site, as a site.
Any decision, any observation, any finding by us would necessarily influence the proceedings of the trial court in suit. That we will not like to do.
My lords, I am not, yes, my lords, it is for the civil court to decide the title of the parties.
Not only decide, anything in any manner we interject, it will have direct consequence either in favor of one party or other party or against one party.
See, your contention is the property is converted for residential purposes.
Yes, my lord.
So question of any revenue entry by way of mutation does not come to the picture.
Yes, my lord.
Fine, we'll give him the liberty to approach the jurisdictional panchayat or whatever to have his name uttered.
Lords, 307, not converted.
appellant.
My lords, kindly refer to
Not
307,
converted.
Annexure R.
It is Gunta's wise, it is continuing, my lord.
May
He
not be-
has-
It will not be converted probably because of the pendency of the suit.
My lords, 307, my lords. 307. My lords, based
See,
on.
the effect of the impugned order is pendency of the suit should find a place in the revenue entry. That's all.
Lords, it has to be, my lords.
Appellant right is also protected.
Huh?
Appellant's right is protected by the order.
Exactly.
Even-
And they want to alienate,
Only
the purchaser is put on notice.
All
Tendency of
proceedings.
Because what
all-
has happened, my lords? My lords, he also purchases a site, gets the kata, my lords, from the jurisdiction Gram Panchayat, entered in his name by the jurisdiction Gram Panchayat. My lords, subsequently, after that, my lords, he seeks for a rectification of this sale deed after a lapse of 4 years. My lords, that is the only grievance, my lords. My lords, I have no grievance to adjudicate the dispute before the learned trial judge. My lords, only grievance is, my lords, once the land is being assessed to tax by the Gram Panchayat, my lords, revenue authorities loses his power, my lords, in respect of mutating the name of the respondent or any of the party or dispute in an RTC, my lords. That is the only grievance, my lords.
They are submitting that it is not converted.
My lords, for a moment, my lords, for only, my lords, annexure, my lords, 249 and along with the 307, my lords, for a moment. The very same respondents have sold this property in my favor, first, my lords, in the year 2010. And subsequently, after 4 years, my lords, they alienate the very same property in favor of Malad 249, Malad the demand register issued by the revenue authorities. Malad Gram Panchayat, Malad 307. Sorry, my lord, sir. Translated copies at 309, my lord. Yes. I'm extremely sorry. 309.
Show us the conversion certificate. Where is the conversion?
Lord's conversion, my lord, the landlord, the very same landlord alienates to me first, my lord. Later on, the very same property is alienated.
That's okay. There is no alien. There is no
For
conversion.
that, my lord, civil title has to be decided by the trial court. Only, my lord, grievance is not, my lord. Now the residential building is there. My lord, I am residing there.
That's really not within the purview of this.
Is all the proceedings are notified in the revenue records, my lord. Even the OS proceedings as well as the writ proceedings are notified in the revenue records, subject to result of the pending civil suit, my lord. It's a suit for declaration filed by.
Let there be an observation. No, none of them should, my lord, meddle with the property, my lord, until disposal of the suit, my lord.
That injunction cannot be granted. You go
Because
for
by
the civil-
taking advantage of this
It is
proceeding,
not
my lord,
title dispute counsel.
my lord, so the
Submission about conversion also is traveling beyond this, probably. So dismissed.
Yes.
Thank you, sir.
Sorry.
well, much of it.
Bill number 28. Mr. Rahmatullah Kotwal.
Yes, for the respondent number 5. I appear for respondent number 5.
Petitioner in this case.
I had just submitted that the instructions would be completed. I've just received my instructions, my lord. Maybe another 10 days time so that I just place it on record here.
I appear for 20 to 65. Comments 20 to 65.
That Mysore Gazette.
Yes.
Yes, ma'am, please. The instructions have been received by me. I'll just place it on record by
When shall we keep?
maybe another 10 days time here. I just get it vetted and just place it on.
7th April,
10th April.
10th April. 10th is holiday or not? Only 10th April.
Yes, sir. 10th is a holiday. 10th April is a holiday.
Holiday. 11th April.
Week after that.
10 to 13.
Yes, 10th to 13th, so the week after that.
15th or 16th.
Then 16th April.
Number 29. Mr. Vital BR. Number 29. Vital BR.
Lord, the connected matter at serial number 18 is posted to 23-4.
Only 23/4. In your submission that the connected matter.
1 of 21 notices have to go.
IN number 1 of 21 is different.
Lord, so what has
No,
happened?
it is for notice not received in that.
Notice is not received
All
in that.
Issue not.
Both the IS, the notices have to
And
go.
32.2,
The same order, my lord.
same order. IN
Same
number
with
1 of 21 and IN number 1 of 25.
Five. My kind,
Return
Matlab.
after vacation.
my kind. Sometime, Lord, maybe
18th.
16th, 17th of April. We'll try to solve, because one of them, one of Velar itself is already on
May
the
not be
card.
possible. Keep it on 22nd April. Let us.
My kind, we'll try to take a chance.
Same application. Number 33, Mr. Anil Kumar BO.
Thirty-three is not adjourned.
They appear for the complaint.
Who appeared for the respondent? What is to be complained?
Complaints affidavit has been filed, my lords.
I have filed.
Seniority list was set aside. We were told to redo the seniority list. So we have redone the seniority list. So it was a subjective order that we have to follow the judgment of the Supreme Court and also Rule 2 of the 1978 rules. So while redoing the seniority, because the earlier seniority list was passed, while redoing the seniority list, we published the draft seniority list, then called for objections. The complainants have also filed their objection. It's also been elaborately considered. And thereafter, we have redone the seniority list, my lords. They say that our seniority list is similar to the earlier seniority list. How it is not similar, we have answered in para 6 and 8 of our compliance affidavit as such.
Complaint is not that it is similar.
All that will consider. We'll go through your pleadings.
Yes.
1st April.
1st April.
34, 35 are urgent. Number 36. Yes, Lakshmi Narayan.
Lots in this,
For
we have
petitioner in
filed.
this matter, my lord, pertains to the civil judge's recruitment, a validity certificate was supposed to be issued by the respondent, lord, accused.
We have filed appeal in this matter.
Other that the same batch have already been sworn, my lord. The second respondent was supposed to issue the validity certificate, my lord, in favor of the complaint petitioner. Directions were issued in the writ petition within 2 weeks.
Appeal has been preferred, my lords. It is filed on 7/3/2025. Writ appeal number 369 of 2025. My lords, objections are cleared yesterday, my lords,
369
of 2025. my
so
lords.
stated that writ appeal number 316 of 2025 has been filed as to challenge the judgment and order of the single judge brought under this contempt proceedings. That the office of license are removed.
Yesterday it's
That
been.
to stated by learned additional government. Promotion, that's one. In that view, the present contempt petition is ordered to be listed next on 21st April, within which time the state assures the court to obtain approved orders.
Obliged.
from the
Copies will
competent-
be directed, my lord.
20.
I may be
Obliged.
permitted to the
I'll,
copies may be served on. Copies of writ.
Give copy. to the
Obliged.
litigant.
Number
That's
37. It's a Subramania PD.
What is it?
But the
Royal decree in terms of. What is your? say?
no internal changes has been done with the said building, my lords.
No.
Because, my lords, the building is aged about 100 years, my lords. Even if
Office
you
is
try-
directed to do decree. Amount is deposited. So this is to be court is to be.
But in this case, they have, my lord, despite the direct undertaking given in the
Where
my
is
lord,
that? Where is that?
in the RFA, my lord, in the RFA, Lord, Annexure C is the, my lord, compromise memo.
So you are against Annexure C order.
Annexure C, my lord. In that, my lord, there are conditions. Under condition number 3, my lord.
Subletting.
First one is, my lord, they were permitted to run a garment business, but by them, but they have introduced it in a third person. And they have produced a bill to show that, my lord, some person, third person is running a garment business. And, my lord, they have removed the supporting wall. I have evidence to show that, my lord, in the photographs.
Yes,
My lord, we are not subletting to anyone, my lord.
you file reply then.
My lord,
Reply on affidavits, reply on oath shall be filed to the allegations made in the contempt petition about the violence of the settlement terms
As per the joint memo.
drawn into form of decree. To further allege that the respondents have sublet
Please,
the premises, handing over the same to third party.
Third party.
To run the business.
Please, my lord.
Which is in open breach of the agreed terms, which was translated into order of the court.
Please.
Yes.
we are not subletted.
File reply.
Yes, sir.
Otherwise, you'll be file on or before 2nd of April. Reply shall be filed before 2nd April, send out to 3rd April.
Please.
Perfect.
38 is urgent, number 39, Mr. Puttegoda K.
Lords, I appear for the complainant, please, my lords. Lordships may kindly forgive me, my lords, for not being physically present. I've hurt my ankle, my lords.
Pardon?
I've hurt my ankle, that's why I'm not physically present, my lords. Lordships may kindly forgive me and permit me to appear online.
Yes. Yeah.
My lords, if your lordships could see.
The order, my lords, is fully complied. Lords, it is communicated to the complainant.
You?
There were some.
I have not received any copy.
Lords, in the translated copy. The lordship may kindly permit me to place it on record, my lords. Translated copy.
Place on record. On 9th of April.
I'll file it during the course of it.
9th of April.
It's grateful.
Number 40, Mr. Vijay Kumar R.
Week's time may be granted.
Week's time. 22nd April.
Interim order may cut.
Interim order shall stand extended
Lords.
till the next day.
Lords, in 40.1, it is a connector matter, my lords. In 40, there's interim order of stay over the matter.
So wherever interim order is, they will be extended.
The same shall be the same stay shall be given in 40.1 also, my lords, because
Necessarily, same date will be given.
it's connected matter, my lords, arising out of same single
Yes,
judge
yes.
order.
Yes, yes. Yes, yes, bound to be.
Please, my lords.
Yes, next. 41 adjourned.
41 is urgent. Number 42, Misha Thomas.
Lordship, only a particular portion of the single bench's order, we need a slight modification, that only after compliance of 17B under the workman's compensation, will we get an audience, the learned single says.
Who is
Give-
for the other?
Notice is yet to be served.
Notice not served.
Notice not
Wait,
served.
since the notice is not served as per the endorsement of the board, the appeal to wait till the service of notice send over to little longer, let it be 23rd of April.
Number 43, Abdul Manan Khan, 14%.
Not provide for consideration. For the reason, my lord, they are seeking for postponement of, my lord, UGCET, my lord, exams which were supposed to be held, my lord, during the month of July 2020 and August 2020. Same timetable, my lord, 13th May 2020 is.
This is what's up. It has become.
Infectious.
Yes, my lord.
Where is the petitioner? Learned additional government advocate Srimati Nilofer Akbar would submit that the petition has been infectious. Petitions have become infectious.
I appear for the petitioner.
You are there?
Lord's matter may be disposed of as it's infructuous. Previous orders.
Learned advocate Mr. So-and-so.
Arnav Bagalwari.
For the petitioner as well as learned additional government advocate Srimati Nilofer Akbar stated that the present petition has become infectious due to efflux of time and having regard to subject matter which has worked out for itself. Dismissed as having become infectious.
Next.
Then which one this is? This will be 43. Then next is 43.3. There is no 43.2.
Not 43, 43.1 and 43.2. Same, they pertain to the same.
Same, so same order will, same order will come. Add the memo, there is a memo of withdrawal on figures on record. Memo dated 18/3/25, seeking withdrawal of the petition number 83893 of 2020. Stating that it is infectious. This petition is also disposed of as infectious in the memo. Then the third one also passes separate order. It was stated that writ petition 8918 of 20 involves same subject matter and it is also rendered infectious. It is accordingly dismissed as having become infectious.
Number 44, SB Mukanappa.
Petitioner in this case. Of mandamus malad, the petitioner is a senior citizenship. In Malad, the fourth respondent is the owner of the residential property bearing number 157. New number 48, Malad 6th class playing card for stage Bangalore. Fourth respondent has converted the portion of the residential house into commercial shop and running the beef stall in the shop without having any valid.
Reply is yet to be filed.
I'll have to find my reply.
Reply shall be filed before the next date, put up on 25th of April.
Number 45, Manjunath.
My lord, requesting to submit the affidavit.
They have taken much time, my lord. They have not filled the reply.
What is that about? Plexus? No, that hoardings in of the politicians.
Yes, Miss my lord, the display of photographs, it has to be removed. They are not filing even affidavit for the last 3-4 hearings over.
Anjali. For Govind Raj Nagar.
Yes.
And the affidavit, they also contain the petition particularly given by the petitioner in their memo dated
Learned Advocate Ms. Pranjali appearing for BBMP wants to file affidavit. The same shall be filed in the
My lord, they have not removed. Even yesterday we have taken photos.
Same shall be
Kindly
filed.
produce this.
Wait.
Simply they are pasting the paper yesterday on 20th or 21st, 22nd, it will be removed immediately in all the places.
You are filing reply.
The pictures are of before and after. My lord, we are not pasting just the paper.
Are you filing affidavit?
Yes.
It will show that, my lord. They have pasted the just
Same.
paper.
The same may be filed. in the
Yesterday
registry.
evening photographs.
The same may be filed in the registry after giving copy thereof to learned advocate petitioner. Full stop. Rejoinder, if any, shall be filed before the next date, put up on 29th of April. On that day, we'll proceed with the matter. Yes. You serve copy and then file in the registry.
Number 46, G. Balakrishna Shastri. Number 46.
Like.
For the respondent number 7, your lordships.
Nobody is there for petition. None is present for the petition. Stand over to.
Both ma'am, this matter, last.
Which are the options? Full stop. On 15/11/24, order was passed requiring the Treasurer into Judicial of this court to examine about the compliance of the office of this. Full stop. The report submitted along with the papers of the petition today include accompanies the accompanied the report. So report dated so and so submitted by Registrar Judicial accompanying the papers of the appeal petition today shows that the compliance of the office of business yet to be acted upon by the petitioner. The same shall be done within 4 weeks from today, failing which the petition shall stand automatically dismissed without reference to or order of the court. Full stop. The order may be communicated to the honorary advocate of the petitioner who is absent today when the petition was called out.
Yes. So, still number 47, so furnishing of process fee, etc.
If I appear for complainant, my lord, furnish the process fee. Further, a 2 weeks time may be granted.
2 weeks time.
Please,
All right.
already furnished the PF.
11th of June as requested.
Much obliged.
Number 48, to Sharon N. Majige.
None is present. Stand over to 19th June. Yes, next.
Number 49, to H.N. Basuraj.
Yes.
Yes. Yes, sir, Sharon.
That side is fixed response. It is calmly said, service is awaiting for R4. R4 have already filed the wakalat representing by the council.
Service is awaited for
No, it is
R4.
now she is filing the wakalat.
Notice is out on the ground.
R4, I'm appearing, my lord. R5, someone else, Reshma is appearing.
R4 is showing,
R4 notice to be served. R5 is already served. Lord, according to the cause list, notice to be served on respondent number 4 second time. R4 is appearing through the council.
I'm appearing for R4.
all are appearing.
Well, as R5 is yet to be served.
ಇಲ್ಲ service ಆಗಿತ್ತು. ರೇಷ್ಮಾ
R5
ತಮ್ಮಯ್ಯ
is already one Reshma Timaya is appearing for R5. All are service served.
ತೋರಿಸ್ಬೇಕು.
Copy is not served on the government, my lords.
You are
Not
for,
appearing, my lords. R5 is not here today.
we take up someone some other day.
And
Her name?
You are for,
R4, my lords, respondent 4.
copy is not served on the government, my lords. Copy is not served on the government, my lords.
Service. 34 delay is in filing the appeal. Delay of 34 days. It could be
let R5 be here, then we'll find out.
very well.
When shall we keep? Any urgency, then this said, otherwise.
He is also appearing.
So we'll count on the delay today.
No, my lords.
32 days.
Appeal only is not maintainable. It is filed by a person who has been terminated as a member and she has resigned, my lords.
We'll see on next. actually.
Please, no.
Keep it. Right. Cover up. When shall we keep?
My lords, next 2 weeks, after 2 weeks.
24th April.
Please, my lords.
It's number 50. 50
And we have taken
Hearing for
and
the-
summons as directed by your lordships to.
There was a
respond and-
preemptory order on 18-2.
Can you order copy? We have served by hand summons. Acknowledgement is already placed on record minute. 14th February 2025, we served the copy by hand summon. Acknowledgement is already placed on record before your lordship's minute. Respondent number 3 and 4. We served on 14/2/2025.
This is coming for the first time.
No,
My
your
lords,
your
I
lordship heard the matter,
Heard the
granted
matter and
interim order.
posted it for final
Second
hearing.
time, your lordship directed us to serve the copy by hand summon. We have served on them. Acknowledgement is already placed on record. According to the first day's order of your lordships, matter has to be heard. That is the finding, my lord, your lordships was pleased to record it.
You are enjoying this day.
Please.
Second so cause notice in the same cause of action.
Yes, very well.
Enjoying this.
Pleading applicant, my lord.
Let the other say.
Pleading applicant.
All up.
I'm for the pleading applicant.
We'll after holidays we'll take up.
Very well.
You are enjoying the. Stand
My
out
lords,
to
they have
16th.
an interim order, if my lords.
It
may
is
con-
not limited. See, it is limited. 16th of June.
May I request for April, my lords?
Pardon?
My lords. The only difficulty is now the
Not limited.
proceedings have been stayed pursuant to the
My lords have directed us not to precipitate further.
There should
After
be no
hearing
further
both the sides,
proceedings.
Milord Lordships
Interim order,
granted
my-
So
interim.
it is not limited.
My lords,
Yes, what do you say?
short date, my lords, April.
Possible. 5th of June.
Very well, great.
Till number 51.
I appear for the appellant. My lords, in this matter, I have filed acknowledgement of serving respondent. In fact, it's even there in the list, my lords. Acceptance of having acknowledgement for having served the respondent, I have already served. So respondent, therefore, no further notice may be, he has still not filed his wakalat. The limited issue, my lords, in this matter is that we sought for some expedited disposal of the matter. My lords, this is a divorce petition in the family court of 2018. It's already 6 years. My lords, I have filed the acknowledgement of having served him personally. He has also signed it. I have filed that in the court. My lords may just see the impugned order. It's just a 1.5-page order at page 12, my lords. Page 12, para 4 onwards. Learned Counsel for Petitioner submits that though the petitioner's petition was filed in 2018, there is no progress in the proceedings and trial court may be directed to dispose of the petition. Para 6, admittedly, petitioner has filed the petition in the year 2018. From perusal of the order sheet, it is clear that respondent has appeared and there is progress in the case. As petition is filed in the year 2018 and several cases are pending, family court is required to give preference to old cases. A direction cannot be issued.
So what do you want?
I just want some direction, even within 1 year, if the family court can dispose of the matter. Ultimately, we just want some, my lords, it is a 2018 matter. Today, the family court has, my lords, in fact, for some ground or the other, the respondent husband is trying to drag on. In fact, that is noted by the trial court in the order sheet, that he is dragging the matter, he is imposing costs. Even this honorable court, he has filed multiple petitions here, trying to get a stay, and all those petitions are dismissed. In fact, my lords may just see, just for a moment, at page 91. In fact, costs are repeatedly imposed because he's filing just one after the other interim applications. Family court has imposed costs on him.
You
My
can
lords,
request the court.
we are just seeking some direction to the court to expedite the matter. Would
Our court says no, some Harish versus State of Karnataka.
No, the order of the learned single judge, in fact, says there is no ground to give this.
Other side is there, we can.
That is, in fact, that was the idea what my lords expressed the last time. You serve him, we can, they should also cannot have any objection to that. But now he's not even appearing after serving him also.
Once again, you wait.
One last date my lords may give. I mean, of course, we have served him. Can be taken on 27th or 28th next week.
28th.
28th.
27th of this month.
Yes, we'll take a short date, my lords.
3rd of April.
3rd of April.
3rd of April. Who appeared?
I'm sorry. I'm sorry, my lords.
Who appeared?
In the lower court, who's the advocate?
Served to the respondent.
No, doesn't matter. Who's the advocate in the lower court? Sushila. Sushila is the advocate on record. One Sushila is the advocate on record in the family court.
You go.
No, we'll serve.
The appearance on behalf of the respondent, those served is awaited. Learned.
We'll serve the advocate on record also.
Jaina Kothari submits that she may be permitted to serve cooperate to learned advocate who appeared on behalf of the respondent in the trial court, so that the intimation of the pendency of the appeal could be given to the respondent and respondent may appear. Full stop. It was submitted that the civil note is about the expeditious disposal of. Is only about the expeditious divorce suit.
Divorce.
Divorce proceedings.
No.
Stand over to giving
What, my lords?
such liberty to. You have not paid process.
In fact, the advocate on record didn't pay process because he served him directly by hand. He'll pay process also. He'll pay.
Process have to do third.
3rd April. Great. Just pay the process. Great.
Number 52, Mr. Ravindra Gajanan Kolle.
Appearing for petitioners, my lords. My lords, it has come up for reissuance of notice for the 3rd time. I will take fresh steps, my lords.
Serial number
52, my lords.
52.
Yes, my lords.
So 52.
Yes, my lords, 52.
So fresh notice.
Submission with council submission.
My lords, the LR was brought on record before the petition court. My lords, thereafter, my lords, this the Srimati Nagaratnama is the one who is prosecuting.
We do not know. There is a judicial shall examine the office of observation, and if the office of observation are dispensable, the necessary endorsements will be made in that regard. Whereafter, the contempt petition shall be notified on board. Next.
My lords, contempt matter, my lords, notice could be issued. My lords, the contempt order alleging is that the 22, there was an order of.
There is some office objection, you just satisfy the registered judicial.
Please.
Number 55. Bhavikatti.
Appearing for the appellant in this matter, my lords, wherein in writ petition, the respondent number 3 and 7 was deleted. Thereafter, the petitioner failed to amend the cost title as well as file the amended cost title. Hence, in the final order cost title, they arrived as an parties, my lords. Hence, I have made an party in the writ appeal also. Hence, I will place the memo and I might be permitted to amend the cost title by deleting respondent number 5.
Do it whatever you want to do. 3rd, 4th of April.
Much
Yes. 51.
Still number 56. 56, Mr. J. Prashant.
My lord.
Some
Appear
office
for the
object-
appellate, some certain office objections are there, my lord. In respect of annexure C, they are in Kannada, my lord. I filed the translated version.
It was stated that the translated version of the Kannada document is filed, of the document Kannada is filed.
My lord,
In
it's
that
over.
view, after examining the compliance, the registry is directed to list the writ appeal for admission hearing on 9th of June.
My lords, can I just request, there's the impugned judgment, my lords. In fact, I am seeking permission to even file this appeal. Because my lords, I was not arraigned as a party before the learned single. My appointment has been set aside.
This is for leave to appeal.
I'm sorry,
Leave-
my lord?
leave
Yes,
to-
my lord, with leave to file an appeal.
So
My
you
appoint-
want earlier.
Yes, my lords, kindly. My appointment has, I've been working for 2 years in the secretariat.
Then 1st April.
Grateful, grateful.
Grateful.
Lords, I'm appearing for respondent number 3. The writ petition PIL.
7, I appear for the 5th respondent. But 5th respondent has been arrayed by mistake, my lord. Lord, this is an allegation that there is a elephant, my lord, there's an elephant, and elephant is not being cared. Lord, that elephant, my lord, in fact, my lord, all the records show that, my lord, it is belonging to the 4th respondent. Lord, 5th respondent is nowhere.
We'll take up on give for it. 7th April.
Lord, can I request for 4th, my lord, 7th, 4th?
4th April.
Yes, grateful.
Still number final hearing matter, still number 58.
May please.
Krishna
Not elephant, madam.
No, no.
Okay.
This in this case is whether
Because elephant always travels, finally will not take. So,
I,
what is this?
no, the short point is as to whether it is permissible for delegating statutory powers of registration under the Motor Vehicles Act. Now, we take our vehicles, we buy a new vehicle. The earlier procedure is we used to take it.
Registration is given to private agency.
No, no, registration, they do the registration.
Pardon?
They do the registration in their dealership or in their premises.
Day to day.
Yes, madam. They don't bring it to the registry of authority. That is question in it. And they have, it's a section 213 says they are public servants. And no, under the Motor Vehicles Act, this amendment, impugned amendment, they say it can be done by them.
Delegated.
It's not permissible. That's the question.
My lord will have to hear on the maintenance.
Yes, I am ready. I am ready.
Still here, not today. Take your date, whatever date. This is of 21. 8th of April.
8th April.
Obliged, my lord.